Hello, my friends. Douglas V. Gibbs here, Mr. Constitution. It's a pleasure to have you, and we need to talk about the presidential election in 2024. Republicans who are adding their names to the candidacy list. So we've got two of them I want to bring up: Nikki Haley, South Carolina governor, and activist, right-wing activist, as he's being called by left-wing media, and basically a money guy in the money type system. Vivek Ramaswamy. Now, we've talked about in the past this idea of eligibility, natural born citizens. So this is what we need to bring up. This is what we need to talk about. Now, when it comes to the presidency, the Constitution states that you must be a natural born citizen. And on the floor of the Constitutional Convention was a volume of books called Vattel's Law of Nations. There were 3 copies on the floor, 1 in French, 2 in the translation to English, which was, I think, 1862, something like that, when the English translation came out. Or 1760, I'm sorry, 1760, 1762. But anyway, on the floor of the Constitutional Convention in 1787, Benjamin Franklin had brought 2 copies of the volumes, 1 in French, 1 in English, and George Washington had brought an English copy of Vattel's Law of Nations. So this tells us that Vattel's Law of Nations was an important a resource for the Founding Fathers regarding the writing of the Constitution. And so therefore, the fact that the definition in it states that both parents need to be a citizen of the United States at the time of the birth of the child in order for the child to be a natural born citizen, which is a step up from citizenship, that is important. That is pertinent. That is an important part of what it is. That is a legitimate definition, and it was important to them. Like I said, that resource was on the floor. Also the 1790 Immigration and Naturalization Act also indicates natural born citizen is both parents being natural born citizens, both parents being citizens at the time of the birth. Some will argue that the 1795 Immigration and Naturalization Act will cancel that out because it didn't mention it. No, it just means that they decided not to put it in that one. But the definition was provided. And then we've got 5 court cases in which, and this is where I love talking to the folks who are not necessarily in full agreement with me on things, because they always go back to the courts. So, well, the courts. Okay, fine, let's use the courts. There were 5 cases in which the United States Supreme Court used the definition of natural born citizen as I am indicating it to be, where both parents were citizens at the time of the birth of the child in the case. So the first one is the Venus case, 1814. This was regarding it has to do with the American Revolution, and whether or not a vessel named the Venus belonging to an American citizen being shipped from British territory to America during the War of 1812 could be seized and taken as a prize by an American privateer. Now, the reason why this is important is not because of what the case was about, but what one of the justices wrote in his opinion about natural-born citizen. Justice Livingston wrote that this individual that owned this boat was a natural-born citizen, and then he quoted the entire section 212 from the French edition, and then using his own English on page 12 of the ruling. This is taken partly from his judicial opinion. Vattel, who, though not very full to this point, is more explicit and more satisfactory on it than any other whose work has fallen into my hands. Then he says, and then he explains the definition of natural-born citizen. So not only is Vattel's Law of Nations pertinent to the persons in the Constitutional Convention, but also to the courts at that point. Second case, Shanks v. DuPont, 1830. Supreme Court heard his case over inheritance received by 2 daughters of an American colonist from South Carolina. And again, they regarding the inheritance for these young ladies, then in the Justice Story, interestingly enough, normally Justice Story is I'm not a fan of, but he gets it right here, gave the ruling, while he does not cite Vattel per se, he gives the principles and definition of natural-born citizen in his in his judicial opinion. Then Dred Scott versus Sanford, 1857, Supreme Court Justice Peter Vivian Daniel considered natural-born citizen as every person born of citizen parents within the United States, and in his concurring opinion in Dred Scott versus Sanford, he quoted the English language translation of Emmerich D. Vattel's Law of Nations regarding this question, that the natives or natural-born citizens are those born in a country of parents who are citizens. That's what he wrote in his judicial opinion. Then we got Minor versus Happersett. In Minor versus Happersett, once again, this was a question about inheritance, estate, and the Chief Justice Morrison Waite, wrote the majority opinion, and he stated, the Constitution does not in words say who shall be natural-born citizens. Resort must be had elsewhere to ascertain that. At common law, with the nomenclature of which the framers of the Constitution were familiar, it was never doubted that all children born in a country of parents, plural, who were its citizens, became themselves upon their birth citizens also. Those were natives or natural-born citizens, as distinguished from aliens or foreigners. Some authorities go further and include as citizens children born within the jurisdiction without reference to the citizenship of their parents. So, Minor versus Happersett, 1875. And then finally, the last example that we have is United States versus Wong Kim Ark. And this is kind of ironic because this is the case that the people who push birthright citizenship uses, and the case doesn't say what they say it says. They say that United States versus Wong Kim Ark says, 1898, that if you're born in American soil, you're just automatically a natural-born citizen and citizen. And in both cases, that's not right, number one. Number two, and we'll get to this in a minute, the argument is, well, the natural-born citizen and citizen, a native-born citizen or born on a soil and automatically a citizen because they're born on soil, that's the same thing as a natural-born citizen. Not necessarily. But anyway, so in the United States versus Wong Kim Ark, which is the son of two resident Chinese aliens, claimed U.S. citizenship and was vindicated by the court on the basis of the 14th Amendment. 14th Amendment indicating that in order to be a citizen, also, you had to be, in addition to born on American soil, you had to be subject to the jurisdiction thereof. What does that mean? And I'll get into that in a minute. In this case, Justice Gray gave the opinion of the court on page 168 and 69 of the record. He cites approvingly the decision in Minor versus Happersett. At common law, with the nomenclature of which the framers of the Constitution were familiar, it was never doubted that all children born in a country of parents who were its citizens became themselves, upon their birth, citizens also. They were natives or natural-born citizens, as distinguished from aliens or foreigners. So that is our legal background when it comes to cases. So your precedent, your case law, whatever you want to call it. Now, we can go a little bit further here when it comes to natural-born citizen, in understanding also that when it came to citizenship, according to congressional testimony by Senator Howard before the United States House of Representatives on May 30th, 1866, when it came to citizenship clause, he indicated that that citizenship was given to those who were children of people who had allegiance to the United States. That's what they meant by subject to the jurisdiction thereof. And therefore, those exempt from citizenship would be the children of foreigners or aliens, ambassadors, diplomats, and other foreign consuls and ministers. So even the question of citizenship requires more than just what we, a natural-born citizen. Now, let's stop right there. I told you I'd go back to something. So what's being claimed today is that in order to be a natural-born citizen, all you need is to be born on American soil. And in order to be a citizen, all you need is to be born on American soil. They call that birthright citizenship. And that birthright citizenship is one and the same for both citizen and natural-born citizen. It's the same thing. They are two different things. We know this because it says so in the Constitution. If citizenship and natural-born citizen were exactly the same, if born citizen and natural-born citizen was the same thing, it would have said so in the Constitution. It says that they are different from each other. This is Article 1, Section Article 1, Section 1, no person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of President. Natural-born citizen or a citizen, two different things. They're not the same. Natural-born citizen, citizen, two different things according to the Constitution. So this birthright citizen being both natural-born citizen and citizen, same thing, doesn't apply. There's something wrong there. That's because natural-born citizen is something bigger, something more. You got to remember, at the time, one of the concerns were the Tories, the loyalists to the crown. Many of these people took arms actually against the patriots who fought the American Revolution. So you literally had, in a sense, a civil war. You had American colonists versus American colonists, some that supported the fight for independence, others that supported the British rule, and fighting each other. And so the Tories were concerned. Tories tended to have at least one parent who was still a British subject or was from and considered themselves a citizen of England. Your Patriots tended to have two persons born in the New World as parents. That was the way it was. That's the way it tended to be. So the natural-born citizen was important to make sure that we kept Tories out of the presidency. That was kind of the point of view. Also, natural-born citizen goes back a little bit further than just America. In Britain, when it came to inheritance and estates, and that's the reason why we saw a couple cases there in the United States Supreme Court regarding that, is in Britain, that when it came to inheritance, you needed to be a natural-born subject. What was a natural-born subject? Someone whose parents were both British subjects at the time of one's birth. Once again, kind of drawing from the same idea. Natural-born citizen, the original idea of a natural-born citizen of having two citizen parents actually goes all the way back to ancient Greece, but that's a discussion for another time. Why do I bring all of that up? Because Nikki Haley and Valak Ramaswamy, or whatever his name is, there's questions regarding whether or not they're eligible. Now, I don't know for sure. I have not seen their birth certificates and know their family tree. But from what I have been gathering, from what information I do have, in both cases, Nikki Haley and Valak, their parents were not yet citizens of the United States at the time of the birth of these two people, even though they were born in the United States. So that brings up an important question. Well, by the way, Vivek, I keep saying Valak, Vivek Ramaswamy. He was born in Cincinnati. Did his parents naturalize before, both parents naturalized before he was born? And see, here's the thing, when I talk about natural-born citizen, it doesn't require natural-born citizen parents or born parents, just as long as are born citizens as parents, but just as long as the parents are citizens at the time of your birth. I'll give you an example. In my case, my wife is originally from Mexico. She was raised here. When we got married, she had a green card. Our children were both born before she gave her oath of citizenship. And so neither one of my children, while they are citizens, are not natural-born citizens. They could not run for president. However, if she and I were to have a child since she gave her oath of citizenship and we're both citizens at that point, then that child could be. Not that that's going to happen, but then that's what natural-born citizen is. So question is here, Vivek Ramaswamy and our South Carolina governor, Nikki Haley, both, by the way, of Indian background, country of India background, were their parents citizens, even if it was just naturalized, prior to the birth of these people? If their parents were, then they're natural-born citizens. If they were not, even though they were born in America, so they are not natural-born citizens. I'll give you a list of other people who are not natural-born citizens. Of course, the most famous one will be Barack Obama by his own admittance. Kamala Harris, both of her parents were here on student visas. She was born in Oakland, but neither one of her parents were citizens at the time of her birth. She's not eligible. Last clause in the 12th Amendment says that the vice president must meet the same eligibility requirements as the president. And I'm actually a part of a lawsuit against Kamala Harris. It's in the Ninth Circuit right now regarding her not being eligible for the vice presidency. But let me now name three more Republicans. So I'm talking about two Republicans here with Nikki and Vivek. Ted Cruz, Marco Rubio, and Bobby Jindal. All three of those are not eligible. Their parents were not citizens, both parents, at the time of their birth. In the case of Ted Cruz, we're not even sure if either one of his parents were. Plus, he was born in Canada. He renounced his citizenship to Canada. I think he might be a man without a country. He's a good senator. I like him, but he's not eligible for the presidency. But anyway, so hopefully that clears this all up. Natural-born citizen, Nikki Haley and Vivek Ramaswamy, and whether or not they're eligible for the presidency. Thanks for watching. United we stand, combined we kick butt. God bless America. My friends, God bless you. douglasvgibbs.com, politicalpistachio.com. Make sure you subscribe to this channel. Hit the notification bell if that's available to you. You can get on my email list. Go to politicalpistachio.com or douglasvgibbs.com and click the link, the little button on the side there that says join the email list. And don't forget also, all of this requires funding. We're always needing funding. And the cost for my radio programs, I have 2 radio programs, one on Saturdays from 1 to 3 p.m. on KMET, 1490 a.m. out of Riverside County, and KPRZ, 1210 a.m. San Diego County, and that's a Salem media station at 9 p.m. Pacific, kprz.com if you want to listen live, or you can look up Mr. Constitution Hour on pretty much any podcast platform for that show. That all takes funding, and the funding for the cost of the one on KMET, well, that went up. It's higher. It's due pretty soon. So we're always looking for funding. We always need to make sure that the ball keeps rolling on this Constitution education. I'm in the process of retrofitting my website, so douglasvgibbs.com may get a different look real soon. So watch for that. We want to make it a educational experience. We're also looking at creating a physical location in Southern California for people to come for Constitution education and also to see artifacts and things like that I have available. There's all kinds of other things we're working on. So funding is always needed. So if you can, douglasvgibbs.com, politicalpistachio.com, and give us a donation. It would really help. All right, that all said, thanks for watching. I hope you learned something. I'm going to try to keep the videos going again. We've had a lot of work going on first part of this year, so it's been a few weeks, but we're back into the groove. So make sure you subscribe. Make sure you keep a close eye on when my videos are coming. Really enjoyed talking to you. We'll see you next time. Thanks.